Okay. Thank you very much. I guess I can say good afternoon now, since it's 12 noon. And welcome to the September 26th meeting of the Act 169 Dual Use of Cannabis Task Force. I've taken the liberty of taking roll. I think the only two task force members that I show that are delayed right now are Dr. Ireland and Wendy Gibson Viviani, but we have 13 in attendance, so we have quorum. So may I call this meeting to order? Thank you.
Thank you, Madam Chair. So just housekeeping, I know we have one in-person task force on today.
I'm sorry, I did not catch that. Could you please repeat?
We have some technical difficulty with the microphone.
You're coming through right now pretty clearly, Judge.
Okay, can you hear me now?
Yep.
Great, okay,
Yes.
Thanks so much. I know we have one in-person task force member, Mr. Gons. I would ask you to make sure the sound of your device in Zoom is muted at all times and for you to speak into the microphone. For those members of the public who are watching the meeting on Zoom or listening by phone, we have two substantive agenda items today. The first substantive agenda item is a task force discussion of the investigation findings of the Social Equity Working Group. The second substantive agenda item is a task force discussion of the investigation findings of the Medical Use Working Group. In terms of public testimony, as with previous task force meetings, as testifiers, you will have 2 minutes to provide your testimony on the agenda items. I will give you a 30-second warning and we'll call time at 2 minutes to provide everyone the opportunity to speak while allowing adequate time for the task force members to work through the agenda items. Testifiers, all testimony will only be heard before each agenda item. Even though today the task force is meeting remotely, we will still entertain in-person testimony, then online testifiers, and then phone testifiers. So let's turn first to in-person testifiers. We're on agenda item 2. Before I ask for any public testimony, I want to remind the public that just last week at the task force September 19th, 2022 meeting, a number of people testified on agenda item 2. So in the interest of time and to avoid duplication, I respectfully ask that if you do testify today, that your testimony not cover what you testified to just 7 days ago. So is there anyone here in person who would like to testify on agenda item 2? Hearing, seeing none, we will now move to online testifiers. If anyone online would like to submit testimony on agenda item 2, and again, just on agenda item 2, please raise your hand. When I call your name, you'll be asked to unmute. Please go ahead and unmute yourself. And if you feel comfortable, please turn on your camera. How are we doing on online testifiers? None at this time. All right. Are there any phone testifiers? No phone testifiers at this time. All right. Madam Chair, we're now ready to take up agenda item 2, a task force member discussion of the investigation findings of the Social Equity Working Group. Who wishes to start the discussion? Task force member, yeah, please proceed.
Thank you. I was going to suggest that maybe if the chairs for the Social Equity Working Group might want to basically just give a brief overview of the primary highlights of your working group report. And you know, we can discuss these and identify any priorities or provide any comments.
Thank you, Madam Chair, for that suggestion. Co-chairs, if you're prepared to give the highlights and themes of your report.
Happy to. Thank you, Michelle. Thank you, Judge. Overview and themes is that there's kind of 3 buckets into which exercises towards social equity can occur, or that would be useful to have legislative action on The first and probably the most extensive as far as redressing the specific harms of the war on drugs is cannabis justice reform. That includes variously decriminalization, expungement, or resentencing, or record clearance, depending on what you want to talk about. It also is most benefited from an automatic process instead of just kind of adding it on to the current process through the AG. And it will take a fair amount of resources to conduct that process, whether it's automatic or not, and some sort of allowance needs to be made for how to do that process. The second kind of bucket is community reinvestment. We called it social equity in the report, and that involves two parts. The first is active and direct reinvestment in those who have been adversely affected by the war on drugs, whether it's through any of a variety of creative options, whether direct payments, low-cost loans for homes and cars, or just educational investments in the area as well. It also includes some of the things that I believe it was the medical use task force touched on as well under social equity, which would be direct changes to maybe the employment law or insurance law or Hawaii public housing to kind of better integrate with legal cannabis market in Hawaii to allow people to participate in the industry as well as in the other parts of the economy. The final kind of section was the equity in the market section, and that was a series of specific recommendations for the independent body that should be regulating the cannabis industry to ensure that there continues to be a diversity of involvement in the industry, to invite in the legacy market, and to make sure that, or to use kind of the concept of a social equity applicant in a way that comports with federal interstate commerce rules to still encourage diversity both in the employment and in the ownership of businesses in the industry.
Thank you, Co-Chair Auditor. The other co-chair wish to say anything before we open it up? Please, yeah. Mr. Gons is going to share some thoughts.
Thank you so much. Just wanted to reiterate the hard work that we do on this committee. I do know that there are some just small mini spelling and grammar edits that I think a revision may be worthwhile here if needed for a final report. And just stating again that a part of this social equity group is that we did an island-wide tour. So we went to every island, excluding Lanai and any of the other, the bigger ones we went to. So we went to Molokai, we went to Maui, we went to Big Island, Hawaii, and Oahu. And sometimes we did 2 meetings on each island to gather individuals and try to get as much testimony from folks and provide equal access to everyone to comment on the social equity space. And I think we had some really, really great input that made it into this task force report. And we have attached some of those comments and things at the end of the report. So if anybody has any questions about how that process went and some of the feedback that we got, I know some of those members are actually on the call as well. So we're happy to discuss how that integrated into our report.
Great, thank you, Co-Chair Auditor and Co-Chair Gons. Committee members, this is an opportunity now to ask any questions of the co-chairs, to make any comments that you have about the report.
I see member Isaac Choi has his hand raised.
Director Choi.
Thank you. Coincidentally, in this morning's newspaper, the transformative justice program in Oregon was unsuccessful. It didn't lower anything. It spells out that I had a long way to go. Why is your transformational justice program any different from that of Oregon?
So to my understanding, the Oregon program the article was talking about was more on the scope of the fact that the legalization of drugs itself would lead towards justice results of some sort. However, the state did not point a lot of funds to that. People were not directed into the programs that were associated with it. And so it's been kind of an administrative element that hasn't been as useful for making that program successful. But at the same time, it is a different category of program than what is happening here, and that this particular program that we're advocating for is directly involved in the criminal justice side, as opposed to kind of the current either harm reduction or people involved in some of the harder drugs, which Oregon legalized. So our goal is to directly interact with the previous applications of cannabis law to those who are involved in the illicit market, to remediate the harms to their ability to participate in the economy. And in that sense, so long as there is resources to help with that resentencing, with that record clearance, then that sort of justice will happen through that process. And it's a
So-
different kind of justice than Oregon.
So how much resources is going to take? Oregon has actually said that they were going to put resources to it. The program was unsuccessful. So what kind of resources are you talking about? And this automatic thing that you're proposing, I thought I saw in your report that you would like to review every case. So is that a big drain on resources that we have in the state currently?
So there are a couple of pieces that we have heard from some of the consultants that were providing information for us. We know from other states that their Department of Justice and their judiciary and their Department of Corrections, because they're no longer processing the large amount of cannabis offenses that go through, they see reductions in their budget or not in their budget, but in their expenditures of between 15 and 30% once cannabis has been legalized. Separate from that amount of savings, in Hawaii, because all of the cannabis offenses are wrapped up into your just kind of generic drug offense, the only way to know if any particular offense needs to have the record cleared or someone is currently in jail and needs to be resentenced is to go back through each of the specific drug cases, read through the police reports, find out if it is cannabis, and then make a recommendation to the judiciary for how to fix that. One of the issues that other states have run into in this process is that if it is not automatic, there is a real need for like a public awareness or public relations campaign to tell people to go take advantage of that particular system.
Okay, so it would be an individual review. So if somebody got busted for 1 ounce of marijuana versus 1 ton of marijuana, there's going to be a review on that, and probably the guy who brought in a ton of marijuana is probably going to be prosecuted, well, still have his current sentence. Thank you, Chair.
Correct. And that'll be in coordination with exactly how legal cannabis becomes in Hawaii. Will depend on, or will determine what that resentencing looks like.
Mr. Radui, I believe you wish to make a comment or ask a question.
Yes, thanks. Thank you, Judge. I want to follow up along the same lines that Director Choi went down the same road. So how far back is the group recommending that these records be reviewed? I mean, I think in the report, there's citations, like, for example, when did the war on drugs start? Was it 1935? Was it 1970 with the passage of the Controlled Substances Act?
In this particular case, it would most likely be 1970 with the passage of the Controlled Substances Act. Prior to that, it was federal offense if you didn't do your registration and pay your taxes on cannabis. It wasn't actually a possession offense at that time. So it would be back to the 1970 CSA. And we would want it to go back that far, because otherwise it is still labeling individuals as felons in a system that it would no longer be legal to be a felon, or illegal for that offense. And so they should no longer be felons, and it should be used to help them again participate in society at a level that they're able to.
And are you suggesting categorical review, that if it's a cannabis related offense, it should automatically be reviewed, or what is the standard of review?
Yes, if it's a cannabis offense, it should automatically be reviewed under the whatever new scheme of legalization exists. So if 1 ounce is fine now, then it should be reviewed for that. If a ton is fine now, then it should be reviewed for that.
And then my last question would be, very significantly in government, there is either a lack of records or inability to gain a record, either because they're not kept anymore or they just cannot be located. So what do you do in a situation like that?
And that's where, if it is automatic, to the extent that we can find records to do, of course, and then there would probably still have to be some level of public education campaign to have people who were previously, like prior records, either bring their records forward or somehow kind of report to see what can be done for them in particular.
Thank you.
Who else has questions? It's hard for me to see who hands that are raised, so I'd encourage you just to jump in.
I do. This is Wendy Gibson Viviani. Hello, can you hear me?
Yeah, what's up?
Yes,
Wendy?
we can hear you.
Oh,
Please
okay,
go ahead.
very good. Yeah, I had similar questions too. You did a great job on this report. Absolutely. Lots of good suggestions on how we might proceed going forward. I too am a little bit concerned about justification, being able to justify the expenses of such a process. I really like the idea of using Richardson School of Law to get as many people involved as possible to get through these records. I'm sure it's a massive amount of records, but I just wanted to mention a couple of things that maybe the qualifying expungements are probably not going to be just for possession only, because back then paraphernalia was the major charge, I believe, and how they got people to make plea deals. So are you going to consider, those points in there also, that, back then paraphernalia was probably the bigger charge than possession. And the courts are saying that they're not throwing people in jail for possession only. So are we talking about maybe just a few hundred people that we're trying to address like right now?
So that goes back to the point of how legal and which elements of cannabis the legislature or this task force is going to recommend that it be legal. Because
Okay.
whatever level of resentencing and record clearance has to be in accordance with that. So whatever level that we decriminalize or whatever level that we legalize, including some of the ancillary things like paraphernalia, then the process would be in response or kind of underneath that level of regulation. To your specific point
Okay.
about kind of possession or the amount of these, we have some evidence that there's approximately 1,200 cannabis convictions each year. And so that can give you a rough number of what we're looking at.
Oh, okay. Okay. So you might be able to justify the expenses of creating an automated system for that. And then also, will you include the harms to medical cannabis patients? It looks like in your listening sessions, I'm looking at page 15 of your report, where the problems that people have been facing are not exclusive to just, adult use users. These are, I've heard from patients who were on parole and continued to use their medicine and tested positive, and so they failed their parole. So, how is that going to be worked into this also? Is that?
It depends again on the specific language that the legislature puts in, but there is definitely the potential for that, in that whatever new version of legalization in its interaction with parole or probation would go back and address those either inconsistencies or inequities.
Okay. And one last question then. As you know, Dr. Otto has been advocating to end the federal conflict with marijuana. And is there something that we can put into this report that would, you're encouraging legalization and decriminalization and expungement of records, but, and that's great. And especially for going forward to reduce the amount of arrests, but is there something that we can put in there to ask the legislature and the governor, the next governor, to take more steps to end this federal conflict? To protect the state's authority, especially as we're looking at federal legalization.
To the extent that the state government has the ability to do that, not necessarily. We are in charge of our own controlled substances like state version, and they can definitely amend that. They can recommend to our federal delegation that they be involved in the process, whether it's the MORE Act or the States Act, and advocate at that level. I know that there are like processes through the DEA or possibly the judiciary. In general, they are either slow rolling those or kicking them back up to the administration to take action. And there has not been any significant progress on that recently. So
Okay.
to the extent that we can recommend that they try to pursue all avenues to get the federal government to move on this, something like that could be added.
It
Also,
seems-
I'm
Thank
sorry.
You have another question?
This is
No,
Michelle.
I'm done. Thank
All
you.
right. And up next is Madam Chair, and then Mr. Leverenz after Chair Nakata.
Okay, thank you. I just wanted to interject just to clarify for the task force that th- just to make sure that everybody understands that any suggestions for input and recommendations to be added, these would be suggestions to be added to the final task force report. We don't have the ability to go in and amend the working group reports at this point in time. And I just want to make sure, that everybody is clear on that
Oh,
already.
I didn't realize that. Thank you.
Okay, great.
Thank you for that clarification, Madam Chair. Next
yeah.
up is Mr. Leverenz. Mr. Leverenz, you have questions or comments?
Oh, aloha. Yes, I had, I guess, a hybrid question comment, and mahalo to Randy and Garrett for putting this outstanding report together, particularly the efforts made to have extended conversations with folks on the neighbor islands. And I think that, as we go forward, it's key to equity that, perhaps this commission recommend coming out of the gate that the threshold that's decriminalized or subject to an infraction be at least 1 ounce. 4 ounce, I believe, is the allowable limit for medical, but for non-medical, it should be at least 1 ounce. I'm aware of the fact that the latest Uniform Crime Report data showed that, post the modest decriminalization law that went into effect in 2020, there's been a bit of a reduction in cannabis arrests here in Honolulu County, but we need to move towards zero on that front. Thank you.
Thank you, Mr. Leverenz. Mr. Gons, did you want to say something?
Yes, please.
Please do.
Sure. So I had 2 comments. One relating to Wendy's point of information required or talking about justification of the expungement. And a part of this too, I think, we had a pretty good preamble on why these things are necessary. And if the state does decide to move forward with an adult use program and legalizing cannabis in the state, that the justification really comes from the policy and how harmful it was to individuals in the past, that it was founded upon a racist kind of preset, and moving forward, how impactful it was. And I really hope that when and if this is taken up, that justification stands as a way is if the state decided to spend those resources to impact individuals in the past, that they take the opportunity to spend the resources to right those wrongs into the future. So hopefully that justification lands for individuals who are seeing this policy. And then also regarding the federal conflict that Dr. Otto has brought up on numerous occasions. We did have a really great presentation from Devon Ward, who is an attorney who has worked pretty extensively in the cannabis space. And in his presentation earlier in this task force, it really has shined a light on that federal conflict issue that I feel as if it would be spending a lot of resources chasing an empty road that doesn't really lead anywhere. And what we could be doing is actually changing our state laws to protect our medical patients and really spending those resources, doing employment protections, and instead of spending a ton of time and resources chasing something that may not even exist, which is a DEA exemption that other states have been denied. So it's worth the conversation, and it does come up often, but again, I'll point back to Devon Ward's presentation he gave to us, and hoping we can address some of our state issues and spend those resources here. Thank you.
In the following order, Chair Nakata, then the co-chair of this report, Garrett Holliday, And then we have Senator Benaventura, who wishes to comment or ask a question as well. So let's start with Chair Nakata. Chair Nakata?
Thank you, Judge Roderick. I just had I had two questions, comments. The first one is, there was some, as you commented, some questions about, how the state might approach, ensuring that, there is some protection for, both the existing, for how social equity could be applied, in the industry. And, Hawaii, the Department of Health is a, member of the Cannabis Regulators Association. And this has been, something that I've particularly paid a lot of attention to in the discussion with other regulators, because as you know, for the current medical use program, we do have a, minimum 51%, Hawaii resident ownership requirement for our dispensary licensees. And it has long been a concern, for our program, as well as other states that have residency requirements, that this would be subject to, a challenge based on the Dormant Commerce Clause. And I think, recently the Ninth Circuit actually did weigh in to, because in the past, I think the way the challenges had survived was the fact that, cannabis, remains, federally illegal, and people have pointed to the fact that, you can't really use, you couldn't use the Dormant Commerce Clause as a rationale for saying that you cannot, employ residency requirements. However, the Ninth Circuit recently, opined that, that the Dormant Commerce Clause is a constitutional protection, and constitutional protection applies regardless of whether you're talking about, a substance or an activity that is federally illegal. It is a guarantee. And so, a number of states, including New York, most recently, have basically lost their ability to, require minimum residency for their, industry applicants, which basically does open the door to multi-state operators, and large corporations, coming in and, swooping up and buying out, companies across the United States, as well as international companies. So I'm just, I was just curious to know if, just based on discussion with other regulators, in addition to the minimum residency requirements, other states have looked at, also using, that the convictions that are being expunged, must have been, within their state. But that's also likely to fall, to Dormant Commerce Clause, arguments. And a number of states have employed race-based, restrictions, but we are also watching that very carefully, because we think that it's very likely that that would fall to an equal protection, challenge as well. So I kind of wanted that's my first question. I think maybe I'll stop here and let, Garrett, looks like he wants to comment on my first question, and then I do have a second follow-up one. Thank you.
Sure.
Michelle.
Let's address the first question first.
A few different things. You are absolutely correct that residency requirements and race-based, issues are not only in question, but actively being struck down in courts across the country. There have been, a few different solutions that have either not been challenged yet or not been struck down, that the social equity group has evaluated and is generally in favor of it. I know the market structure group did as well in their report. There's, a few different options to help bring equity to the industry. First is lower license fees, allows for equity in the industry. That is separate from kind of the purpose of the social equity report, where there's two ways, to kind of achieve what you're looking at. The first is tying some of the equity licenses to, neighborhoods or zip codes that were adversely affected, because then it's not race-based and it's not state-based, and that has seen some success in court so far. And then the other way is, rather than, restrictions on ownership, reserving like positive support for equity applicants, however you define them. And both of those are currently potential, directions, for doing this legally.
Madam Chair, any follow-up to that? And if not, I know you had a second question as well.
No, just a second thought. I think that was the reason why one of the things I've also been really interested in is using community reinvestment as a mechanism for providing some remediation, as a result. My second question, and I don't want to stir up the pot or get people upset or anything, but based on the last meeting, I think there was some fairly healthy questioning and discussion around the subject of a definition of Native Hawaiian. And I think that is something, and this task force is not meant to make decisions, but I think primarily, the subject matter is far too complex. I would suggest that in the final report, it might be helpful if we can gather some proposed language about how Native Hawaiian might or should be defined, for consideration in any future legislative efforts. And that was more just a comment rather than something for discussion. But if anybody has any feedback or thoughts about that, I'm happy to hear them, as well as I think the rest of the group would be. Thank you very much.
Thank you, Madam Chair. Any thoughts based on Madam Chair's last suggestion as it relates to defining Native Hawaiians?
Randy?
So this comment's kind of in tandem to the race-specific language that we tried to outline in the social equity report and to that definition. So we did include some citations to a report from New Leaf Project that lays out the way to have race-based and specific language that meets the requirements constitutionality. And it requires you to show a certain level of things, desperate impact, and kind of lay out the case for why it's needed and have the policy narrowly tailored, which I believe in our report, we suggest that be the course that we take to meet those requirements and be able to do it in a legal way that won't be challenged and overturned. The report is pretty well done. It's about 16 pages included in the citations, which I think would be good to review to see if when and if adopted, we can provide that to the state to kind of take that course of action. And then in terms of defining what is Native Hawaiian, I would suggest that we consult with individuals from that demographic to kind of speak to that. And maybe if we need to have some kind of expert opinion on how to recommend that language, and or we just recommend generally that when thinking about this policy moving forward, that the legislature do that work themselves.
Thank you. Task force members, next up is Mr. Howard and then the senator, but Randy and Terry indicated they wanted to speak. If either of you wants to speak on the issue of defining Native Hawaiian, this would be the time to do that. If you want to talk about other things, we'll take you in a little bit. Okay. So Eric, was there anything else you want to share?
Yes, I wanted to briefly respond to Nikos's comments in regards to the 1 ounce limit. And there's a couple of pieces to put there. The first being that any particular limit that other states have put on what is criminal or not criminal has resulted in greater racial disparity in the arrests that continued to happen. Not just like more arrests, but there was actually less majority arrests and a greater percentage of minority arrests in those states, which is why the social equity group recommends making it A, an entirely civil process, and B, being generally as legal as possible. This mirrors some of the language in both the market structure report and the tax report as well. So to show that there's kind of broad support for this idea and the placing of all of that enforcement inside of an independent regulatory body. Thank you.
Thank you. Senator, you've been very patient. It's time for you to make a comment or ask a question. Now you indicated a desire to do so. So Senator.
Yeah, thank you very much. And I'm a member of this subgroup. So I would at first like to thank Garrett and Randy for having the community-based meetings. And as you know, I participate in a number of them. So we've heard stories, and I missed the last meeting. But we've heard a lot of stories, and my community in particular had been really economically impacted by the war on drugs. I mean, I think Garrett and Randy didn't quite realize how vast the difference that the war of drugs had impacted my community until they did the listening session. So what I want to point out is basically what Director Isaac Choi had pointed out. You know, the amount of reparations, potential reparations, if we want to actually go through this thing, is going to be huge. So I don't know. I think ideally this automatic recommendation is the ideal, but the reality, it's probably going to be based upon a claims-based basis, based upon a number of funds that would be available. And regarding the Native Hawaiian, you know, the Native Hawaiian, as a legislature, the Native Hawaiian definition pops up all the time, and not just based upon this, okay? It's DHHL requirements among the, and I don't know whether or not, and I agree with Randy in that I don't think we need to define Native Hawaiian right now, just to be able to show that it has impacted the Native Hawaiian community as well. And that was based upon all the listening sessions and the districts, as Garrett had pointed out. Maybe we just do it on a zip code basis. You know, a lot of listening sessions had pointed out, and I also pointed out that I was innocent victim on this war on drugs, when basically these Green Harvest helicopters came down and ripped apart tarps that we were building up just because they didn't want to get the search warrant, you know. And nobody, I don't think I'll be able to ask for reparations, but it's not just this one. It was like a number of other innocent people who were impacted, okay, and who don't have the money to go fight the county and having this Green Harvest helicopters that came and impacted them. But regardless of that, I think we're doing the best that we can to at least address the various issues. And I want to thank Garrett and Randy. And that's basically all I want to say. Thank you.
Thank you, Senator. Mr. Gons, were you prepared to speak to this at all before we hear from Ms. Gorman? Ms. Gorman, you're next. Okay, Ms. Gorman? You're
Sorry,
up.
Judge, sorry, Judge, may I respond to Senator?
Of course.
Sorry, Terry, thank you. Thank you very much, Senator. Absolutely, in many respects, and you're right about the resource constraints. I do want to draw for the task force one distinction in that she is absolutely correct that reparations themselves or any sort of community reinvestment will most certainly have to take base on a claim basis of some sort. The report from the task force for automatic is very specific to resentencing and record clearance. So it's just the administrative part on the criminal law side and not directly connected to reparations. It's still going to take resources to do, but a different level of resources than automatic reparations.
All right, thank you for the clarification. Ms. Gorman, you've been very patient. It's your turn.
Thank you. It took me a while to get unmuted earlier, but I would like to address briefly the issue of who is a Native Hawaiian. Unless and until the federal government recognizes the existence of Native Hawaiian people as a separate group, Hawaiians remain the only indigenous group in North America or that's associated with the United States that has no federal recognition. So that, number one, is a problem. And it is difficult to it's difficult to understand because on the one hand, the federal government established the criteria for participation in Hawaiian homelands situation, and they've taken sort of a hands-off position with regard to Kamehameha schools, but I would recommend speaking again with Kamehameha schools and other Native Hawaiian-based organizations to understand their how they determine who does have Hawaiian ancestry. In Kamehameha schools, they do have a data center, Ho'oulu Data Center in Honolulu, that checks for the existence of a Native Hawaiian ancestor. You have to have proof of it. It's not a matter of going in and say, yes, I'm part Hawaiian. That's one way of defining it. Another may be participating in programs such as Hawaiian Homelands programs, etc. However, the part Hawaiian demographic in Hawaii is one of the largest and fastest growing demographics in Hawaii. And there's very few pure Hawaiians left in this day and age. So I support the suggestion that this group not try and solve that issue, but take into consultation advice from Hawaiian serving organizations on how they identify who is and is not of Native Hawaiian ancestry. And that's my comment. Thank you.
Ms. Gorman, thank you for your comments and your suggestions. Mr. Leverez, I believe you're up next.
Aloha. I just wanted to float the possibility that regarding potential constitutional obstacles in adopting a race-based program or one that excludes outside investment, is that perhaps there's a possibility for the state, to act as a market participant to sort of obviate the Commerce Clause concerns, as well as to cultivate, the participation of small farmers and producers. Of course, we don't want a situation where it's like in Oregon with liquor, where the state becomes the purveyor of a particular good, but there's an opportunity there if it's carefully done to ensure that impacted communities, whether they're in a certain zip code or who have been harmed by the drug war, to be able to participate in a prospective adult use market. That's all.
Thank you, Mr. Leverance. Director Choi.
Thank you. Interesting comments about how we can do social equity via geographic zones such as zip codes or neighborhoods. Do you think we could have an opt-out provision? So let's say Manoa doesn't want drugs, so we can say, no, we're not going to allow any type of drugs. Could that be part of our report, not only opt-in by neighborhoods or geographic location, but an opt-out provision for this particular social equity type of project? You're muted. You're muted.
Is it not working? Can you hear me?
Yep, I can hear you now.
Okay, great. I'll address the opt-out provision. So when looking at other states that do have an opt-out provision of certain areas that do so, has caused significant issues in the growing of the illicit and non-regulated market. Specifically looking at California, they have an opt-out model for their specific counties. So some counties say yes, some counties say no, and some people get around it by allowing delivery into each district if they'd like, and they can bring it to you anyway. And then those in the opt-out districts that don't have a licensed and regulated dispensary are seeing a proliferation of illicit market operations, which doesn't meet the end policy goal. So, I know that we do have an unfunded mandate issue here in Hawaii in our Constitution. So, preparing each county, if the state does decide to go this route with some level of resources, I think is addressed in the tax report for giving them a piece of it. But starting to allow people to opt out, in my opinion, causes a lot more issues than it does solutions.
And
Thank you.
To the extent that the social equity literature has addressed this as well, it is chiefly your more well-to-do neighborhoods that have selected to opt out, like Manoa, and it means that there is an over-concentration of whether it's processing facilities or retail locations or grow locations in the more economically not as advantaged neighborhoods as well. with some impacts on those, negative impacts on those neighborhoods for it to be so concentrated in them.
Thank you.
Yeah.
I don't have, is there anyone else who wishes to speak to this agenda item? I don't have any other names that have been handed to me. I'm going to give you a final opportunity to ask any questions or make any final comments.
Sorry, I did just want to make one comment, just mostly to affirm what Garrett just commented on, that other states that have opt-out provisions have seen that happen. I mean, Hawaii's a lot different than those other states. We're nowhere near the size of someplace like California, where an entire county. I guess we could say that we could have an entire county, but if you're talking about city by city opting in and opting out, there's drive 5 minutes or walk 5 minutes even, and you can be in another city. There has been a lot of comments from other discussions I've had with other regulators in other states, is what's happened then is that there's been a proliferation, like Garrett said, of the manufacturing production as well as the retail being located in those actual communities that were disparately impacted, and them ending up bearing the large burden of the industry. So that's something that we should be sure to consider as well. Thank you.
Thank you, Madam Chair. I want to thank the co-chairs, Gons and Holiday, for your presentation and your report. Also thank the task force for a very robust and fruitful discussion. We'll now turn to agenda item 3. Before I ask for any public testimony, I again want to remind the public that just last week at the task force September 19th meeting, many people testified on agenda item 3. So in the interest of time, to avoid duplication, I respectfully ask that if you do testify today, that you not repeat what you just testified to 7 days ago. So is there anyone here in person who would like to testify on agenda item 3? Seeing none, we'll move to online testifiers. Anyone online would like to submit testimony on agenda item 3, and again, only on agenda item 3. Please go ahead and unmute yourself. If you're comfortable, please turn on your camera. I'm being handed a name now. Dr. Otto, you are up.
Aloha, Chair, members of the task force. Dr. Clifton Otto here. I just wanted to thank the Medical Use Working Group for highlighting the federal conflict question in its rapid survey last week during its presentation. I think this is the first time we've really had data confirmation of negative consequences that patients have been telling us about for years. And I hope that the task force will consider adding a recommendation that addresses this to the final report, especially since it seems to stretch across at least 2 working groups. I've been researching this for the past 10 years. I'm sorry to be a broken record on this issue, but I get calls almost on a weekly basis from patients who are suffering from this, and have an ethical duty to do something about it. I believe the state also has a duty to look for solutions. And so to say that approaching the DEA with the recommendation that was in HCR 132 is invalid, I think just isn't true. This is a approach that other states are working on, and something that Hawaii could easily piggyback on so that they don't need to put exorbitant amount of time and effort into it. This is already something that's being pursued by very competent individuals. The DEA may put up with some resistance, but I'd like to remind the task force that it was recently discovered that the DEA was illegally operating their federal cultivation system for the past 50 years. This was pointed out by the OLC and was brought to the public's knowledge. And so the DEA sometimes needs, certainly if this is something that could be done with other states. I think those are my comments.
Great, thank you very much.
And I'd also, I think I had a few more seconds. I just wanted to add that the legislature really went out on a limb on this issue during the regular session of 2021. And I think they need our support. And so anything that could be in there, as Garrett was saying, just kind of a broad recommendation that the state could pursue all options that are available to it to try and address a conflict that it created 22 years ago. So thank you
Thank
very
you,
much.
Doc.
I'm available for any questions.
Thank you. Task force members, any questions for Dr. Otto? Hearing none, we have another online testifier, May Poe. Ms. Poe? Ms. Poe, are you there? All right, we'll go on to telephonic testifiers. Any telephonic testifiers? I'm sorry. Is this virtual? May, is that you?
Yes, it's me.
Please proceed.
Okay, thank you. Thank you so much for this opportunity to testify on this agenda item. When it comes to the report, I think that it was very well thought out, and it has a lot of things that can be put into action now in our current medical program. I think some of the things that can be done now are the testing for THC to have essentially have that to where people who are employed who have medical cannabis cards will no longer be tested for THC, and I think that that's something that can also be rolled over for an adult use, and also again for people for education when it comes to the Department of Health. I think that that's also something that is really, really important for them to provide education when it comes to cannabis use. I think a lot of our patients are seeking that type of education, and we as healthcare providers do give that, but also there are some people who don't have that, and we're seeing the consequences of it. And thank you. That's it.
Thank you, Ms. Poe. Task force members, any questions for Ms. Poe?
I do have a quick question, please.
Please proceed, Madam Chair.
Hi, May. Thank you for your comments. Just a point of clarification. And it may have been because I wasn't listening very carefully, sorry. Education requirements, you want educational materials for patients, or are you suggesting that the state actually make educational requirements for medical providers? Because I know a number of states do require that.
So I actually think it can be threefold for medical providers that are providing certifications, for people who work in the cannabis industry, for bud tenders, and also for patients. I think we've seen a lot of really good examples of this. Canada has so much great, they've done a really, really good job with this. I recently worked with the state of Ohio to where I helped to sign off on their educational program that was for bud tenders. Everything was electronic. So it was super accessible and really, really easy. And all of the providers and the bud tenders received a certification and then were able to work in that area.
Thank you, Ms. Poe. Any other task force members wish to ask Ms. Poe any questions? Hearing none, we're now ready to hear from Care Wailu. I just want to remind our testifiers, we are focusing exclusively on the investigation findings of the medical use working group. Care Wailu, please proceed.
Here we go. Can you guys hear me?
We can hear you clearly.
Great. Yeah, there's a lot going on in this group, and I'm just here. I'm actually here in the state of Maine this week, going to the cannabis conference and reviewing their medical bills. And I'm not trying to jump off task too much, but the Americans for Safe Access Award awarded the state of Maine a B in the letter grade of A through F, and the state of Hawaii a D. So when we're talking about social equity, we're talking about fairness and stuff like that. I think we really need to.
Sir, we're actually talking about medical use, not social equity.
Okay, so we'll go back to medical use. So this is why I'm here. So we're talking about the medical use program. And that's where we're at right now. So in my opinion, the state of Hawaii has not embraced their medical use program. And that is the biggest problem for a lot of things. So for example, in this medical use program in Maine, anybody can get a medical use card, a caregiver card, and open a dispensary, deliver. So this is already a huge big deal for local people, both indigenous and residents of Maine. So I would say for the task working group, and although a lot of work has been done, you guys, this is happening really fast. And this is only like 3 months of work when we were supposed to start on this like last year. So there's a lot of stuff going on that we really have a lot of work to do. And even the meetings that we had on islands were really small and only a few people. So I'm going to go right back to medical use and say, hey, this is the most important thing. This is the most important thing we can do right now, is to engage this medical use program and make regulations for it before we even step into 21 and over. And then you can start talking about expungement. New York's at like 180,000 doing an online system. So, okay, thank you.
Thank you. Any questions for the gentleman from Karawailua who is in need? Any questions? Hearing none, we're now ready to hear from Sam Delapaz. Mr. Delapaz. Mr. Delapaz, are you there and are you ready to testify?
Yes, I am. Can you hear me all right?
We can hear you very clearly. Please proceed, sir.
Great. I'll keep it brief. I just wanted to basically mention in response to the considerations around opt-out and in regards to Randy's comments as well, in California, one thing that we saw was a large amount of opt-out, and that created, a lack of revenue being generated in certain communities because of maybe some louder voices pushing for opt-out. And a lot of times it was not parallel to the voters' consideration, what the voters wanted essentially. So I heard recently of another location that was doing it based on voter turnout. So anything that would be regarding an opt-out, I would absolutely, I would navigate away from that, but I would say it needs to be put up for a vote by the community, if anything, and not just be something that a city manager can decide essentially. So just wanted to put that out there. And then in regards to the medical, there was another thought I had, but I just lost it.
All right.
Mostly, I just want to support on that one component.
Task force members, if they have any questions based on what you have testified on. Any questions for Mr. Delapaz?
Hi, yes, I just wanted to ask the prior speaker whether he had any opinion on, in his experience, on the importance of having uniform rules, statewide rules, in the jurisdictions that he's had experience in, because I used to work, for around the policy process in California, and with the county governments, you basically have almost 57, nations within, well, not nations, but very strong governments within the larger state government. And from what I've observed, I can reaffirm, his contention that the adult use cannabis regulatory framework is scattershot at best. It doesn't achieve revenue goals, and it leaves many communities underserved. That's not to say that there can't be, zoning considerations at the local level, but I think it should be confined to that rather than, having neighborhoods or even entire counties, banning adult use cannabis. Thank you.
Mr. Delapaz, any reaction or comments to that?
Yeah, I will just say that I agree. I mean, I think that, if the voter turnout is in favor of legalizing cannabis, then it's much easier and much more likely to see the desired revenue generation and the equal, access and availability to cannabis by making it more of a blanket allowance. And then, yes, absolutely, sensitive uses such as schools, parks, things like that are very important to consider. But other than that, I think absolutely, without broad access, you end up with very limited market and a lot of work, again, on the regulator's shoulders.
All right, thank you, sir. The last virtual testifier we have is Abby Amerdash. Ms. Amerdash?
Actually, I have a question.
Oh, sure, please pose it.
Okay, I'm sorry, Mr. De La Paz, I have a question for you. You're bringing up a novel concept called voting. Do you feel that adult use marijuana should be put to the vote of the people?
I mean, that depends on exactly how, you choose to approach legalization in the state of Hawaii. Vermont recently passed, legalization through legislature. I think that overall you see, a broad support, and you would see it in Hawaii, absolutely, I believe. But, I'd say if it comes to, I'm speaking specifically to the concept of opt-out, and I wouldn't allow that unless maybe there was a community fully voting that in, based on constituency. But yeah, those are my thoughts on that. I would, again, veer away from that because we've seen it be a detriment to multiple states by allowing that, specifically California as your best use case.
Yeah, the
for how
consent
bad
of the people is a novel concept here in Hawaii. Thank you, Chair.
Any other questions from Mr. De La Paz? Hearing none, thank you, sir. Final virtual testifier, Ms. Abby Amerdash. Ms. Amerdash?
Hi there. Thank you for having me today. And thank you, everyone, for having the opportunity to testify, and the task force members for all their hard work. I wanted to just, the medical group honestly did a wonderful job with the report. It's very well thought of. But I like the part where they said when it came to taxes that it's not going to be raised on the medical patients. And that's, I appreciate that. I would like to just add one thing that I do encounter with some of my patients actually who are on disability and a limited income. It is really, even with the current prices right now, it's very hard for them to afford their medicine, and they go sometimes without having to go without medicine because of cost. So if there is for disability, people who are on disability, like if we can amend it to add that they can have prorated rates just for this population, that would help access to medicine. And I also am in favor in having a educational program that is to benefit the patients and to benefit any provider who wants to certify people, and also to people operating dispensaries and bud tenders. And thank you. I've been involved in the last year or so with educating actually different providers.
You have 30 seconds. I'm going to ask you to wrap it up, please.
Thank you, Judge. I've been involved in educating providers in the community, especially hospice providers, about using cannabis with their patients. And I'll be more than happy to help.
Thank you very much for volunteering for that. Task force members, any questions for Ms. Amerdash? Our hearing none. We do have a phone testifier, 808-298-9228. I'm going to ask that individual to press *9 and at this point press *6 to unmute yourself, and you can then proceed.
Hello, can you hear me?
Yes, we can hear you very clearly.
Thank you. I just realized there was no patients or severely disabled on this task force, and it was a small survey. As a patient, I don't think testing is a priority as much as it was identified in this for me. A legal, stress-free, unlimited use should be the main goal to make this 22-year-old dream of health center into reality. Shouldn't call the Office of Regulation and Control as it furthers false stereotypes that this is more dangerous than other foods. Star fruit can kill you, and it would be better named Office of Medical Cannabis Compassionate Care and Education. I don't like the advice from Canada that kind of compares growing to having disability dispensary access, like the case of Cambodia and the antidepressant cow. That's a good story. Not cultivation is therapeutic. For the federal issue, I think they should work with DEA to get the production license subawarded to patients under a federal study that would allow the patients to be studied as well. That would help the federal issue. For the recommendation 1, I think it should also include patients with conditions that are required to be treated with cannabis to avoid a potentially fatal situation, or when the benefits outweigh the negative
30
impact.
seconds, sir. 30 seconds to wrap it up, please.
Thank you. Like if there's a medical history such as a traumatic brain injury, AVM, or CVA, seizures, studies show that if you have cannabis, it can reduce the risk damage of a stroke by 15%, which is also known as a CVA. So under recommendation 1, I would add that. For the second one, disabled patients growing consumption.
Sir, your
stress.
time is up. Your time is up. I'm gonna have to wrap you up at that point and ask the task force members if they have any questions for this gentleman. Any questions for this final testifier? Hearing none. Thank you so much, sir. Madam Chair, we're now ready to take up agenda item 3. A task for, hold on, I'm being told that we might have one final. Is this a phone? Online virtual testifier? The persons identified themselves as Kevin. Kevin, you are our last virtual testifier. Are you ready to proceed? Kevin, are you there? If not, we're going to move on. Okay, we're now ready to take up agenda item 3, a task force member discussion of the investigation findings of the medical use working group. And to follow Madam Chair's suggestion before the co-chairs for this working group are Ms. Corman, Mr. Leverez, perhaps you can give us the highlights and themes, and that will start off the discussion for the task force.
Terry Gorman, representing Mayor Victorino from the County of Maui. As discussed when we presented our findings, we based our conclusions on a survey that was deployed to approximately 34,000 patients on the state's registered medical cannabis registry, as well as approximately 300 certifying medical professionals. The goal of our task force was to focus solely on the needs of participants in the medical cannabis program as it exists. We asked questions in the areas of medical considerations, needed patient protections, and education. I feel very strongly that the existing program in the state of Hawaii that was based on patient safety, public safety, and product safety has performed well. Having said that, regulation has been inconsistent, I believe. And what we found from the patients, at least I will speak on behalf of myself, is that I believe Dr. Otto did bring up a good point about the problems caused by the federal conflict, not just for patients, but also for the medical professionals, not having any legal training. I don't know if the state of Hawaii taking action in that area will be fruitful, but I'm open to including a general recommendation along those lines. And with that, I'll turn it over to Nikos, who can talk specifically about highlights of some of our specific recommendations moving forward. Thank you.
Thank you. And once Mr. Leverens is done, we do have that individual named Kevin. We do need to give him a right to testify. Mr. Leverens, why don't we hear from you first, then we'll hear from Kevin, and then we'll continue with the discussion.
In order to clarify sort of our goals, among our top goals are to ensure that medical cannabis patients are not negatively impacted by the prospective adult use market, and to preserve, protect, and perpetuate state standards that ensure patient safety, including testing requirements for purity and quality of medical cannabis and cannabis products. Under medical considerations, we have a list of 10, but we would recommend that registered medical cannabis patients retain their right to grow their own cannabis plants or designated caregivers provided by law. We recommend that all cannabis and cannabis products intended for sale or distribution be subject to the same testing standards currently provided by law to ensure safety and quality of commercial cannabis statewide for medical use. We recommend the elimination of a state-determined list of qualifying conditions as a requisite for registration as a medical cannabis patient, and instead respect the doctor and patient relationship or provider and patient relationship by allowing qualifying physicians or AAPRNs to make that determination. Really briefly, we also recommend that medical cannabis patients remain exempt from any new taxes that may be levied on cannabis or cannabis products in the adult use program. And whether or not one day we eliminate taxation of pharmaceuticals is another question. And finally, we recommend that medical cannabis dispensaries be authorized to provide delivery services and curbside pickup to protect patient health and privacy and to ensure access by homebound patients, those in palliative care, and those with compromised immunity. In terms of patient protections, among our recommendation is that we need to see, we would like to see legislation for employment protections for medical cannabis patients that include hiring, discipline, and termination, and provide that a positive drug test for cannabis metabolites shall not be constituted as proof of impairment on the job, and that employers and insurance companies be prohibited from medical discrimination in this regard. In terms of patient and public health education, as I said in our last meeting, we recommend, as the last task force did, that the State Department of Health develop and deploy a public health education campaign about medical cannabis use, safety considerations, and how to identify signs of psychological dependence. And that we also recommend that the John A. Burns School of Medicine include cannabis education that's evidence-based and unbiased in its curriculum, similar to the National Council on State Boards of Nursing 2018 recommendation for caring for the medical marijuana patient. So that's all I have for right now. Mahalo.
Thank you very much, Co-Chair Leverance. We'll come back to the task force in just a minute. We have that final phone testifier. We ran into some technology problems. Kevin, I'm going to ask you to press star. No need. He's ready to proceed. Kevin, we're ready to hear from you. Kevin, I'm going to wait about 10 more seconds. We've tried to be as patient with you as we can. We've actually interrupted the task force discussion to come back to you. And we've tried our very best, but if I don't hear from you in the next 5 seconds, we're going to move on. All right. Task force members, this is now time to ask Ms. Gorman and Mr. Leverez any questions you have, any comments you might wish to make about their working group report. Please proceed. Does anyone wish to comment? Any questions that you have? Any comments that you have about the report?
We have a number of raised hands.
I have a long list. First is Dr. Choi. Dr. Choi, Director Choi.
Thank you. Thank you. I just want to clarify one of your recommendations. Number 7, you recommended that all cannabis products should be tested using the same testing standards. But at the end, you put quality of all commercial cannabis. So are you saying only commercial cannabis should be tested? What about the homegrown ones and the other cannabis? Could you clarify that particular recommendation for me, please?
Yes, Mr. Choi, I would like to clarify that. I believe on speaking on behalf of the members of the task force, the possibility does exist right now for those who choose to grow their own cannabis at home. They do have the ability to have it lab tested. And I believe that should be a personal decision by each patient. But any entity that is growing large amounts of cannabis for more than one or two persons should be subject to product testing, simply because the risks of growing a large number of plants together increase exponentially with the number of plants with regard to contamination and other things. And so our feeling is that individuals, if they grow their own products and they feel safe in using the products that they've grown and they don't feel the need to lab test their own products, I think that's fine. But anything that's being sold by any entity should be tested, especially for medical use. A number of patients who use medical cannabis are using it for cancer. They have compromised immune systems or other underlying health conditions that could be exacerbated by contaminated cannabis products.
Okay, so are you saying that whether it's medical cannabis or recreational cannabis, it should have the same safety standards?
I just want to clarify that our group only considered the issues related to medical cannabis use. We did not consider or discuss issues related to adult recreational use.
Thank you, Chair.
Thank you, Director Troy. Senator Bonaventura, we're ready to hear from you.
Yes, thank you so much. And thank you so much for the people who created this report. But one of the questions I have regarding the appendix, as well as a potential solution of unintended consequences, was not addressed by the report. And that is, it appeared to me that there was high negative consequences when cannabis, not medical cannabis, but when cannabis is used by those who are depressives or some kind of psychosis. So what I'm trying to ask as a health committee member is there a potential recommendation that would not qualify conditions should a patient be a depressive or psychotic? I mean, when there are indications of psychosis or depression, is that going to be a contraindication to prevent a patient from qualifying to get medical use cannabis?
I think it would be left up to the medical provider or APRN to determine the range of conditions that any individual patient has before them, and to make determinations whether or not cannabis is appropriate for them, whether for treatment of severe pain or an anxiety or potentially other mental health condition, certainly. And our intention here was to enable providers, including APRNs, to make those determinations using their skills and knowledge and their familiarity with the patient before them, to determine whether or not medical cannabis would be of benefit to that particular patient.
So I want to follow up, and the reason is, as a legislator, every session, medical cannabis proponents keep wanting to have us include qualifying conditions.
Yeah.
And since there is a huge push in the federal arena as well as the state arena to reduce suicides, which is a huge, it's now considered a federal medical concern, right? Suicide. Maybe that would be considered as a contraindication for a qualifying condition. I don't know. That's why I want to know whether or not that's going to be a potential conclusion for this report. The second thing is, I noticed that there hasn't been, or has there been any kind of differentiation between cannabis that is smoked versus cannabis that has been baked? Okay,
I'm happy to answer that for you,
Thank you.
Senator San Buenaventura. Regarding contraindications to the use of medical cannabis, I fully support having the medical professionals who've been properly educated about medical use of cannabis and making that decision. Right now, if you come in to see a medical professional, the only thing that you have to have is a so-called qualifying condition that's recognized under the state of Hawaii. Presumably, most of our certifying medical professionals are getting more in-depth information about each patient. However, we always know that there are bad actors out there that are just there to get their certifying fee and really don't care. And for that reason, our group is suggesting doing away with the state's list of qualifying medical conditions. Some of the reasons being is that cannabis research, medical cannabis research in the United States tends to be far behind research done in other places due to the federal prohibition and the way cannabis research is funded in the United States. So those looking for the latest information in medical cannabis efficacy and side effects are better off looking at studies done in other countries. So that's the first thing. The second thing is, I personally believe the patient-physician relationship is one of the most important with regard to use of medical cannabis. And that means follow up with the patients. How are you doing? What and what? Absent of that, I believe that trained dispensary workers can play a certain role in that, and they can identify if they might see concerns and maybe recommend to the patient that they go back to their qualifying professional. I am not a medical practitioner whatsoever, but we do have Wendy Gibson, who is a cannabis nurse. She's been through years of training and has quite a bit of clinical practice, and she's seen a lot of it. I've also spoken with a number of physicians and researchers in the area of medical cannabis, and they tend to agree with this, that it's for medical use can be managed a little bit loosey-goosey because of the misunderstanding that it's perfectly safe. You can't overdose on it, nothing happens to you, but that's not necessarily true. There is a small minority of people that do have potential for psychological dependence on cannabis. It's not physically addicting, but it absolutely, there is potential for psychological dependence, and it can exacerbate psychosis and other mental illness like that. And in our group, we are all about safe and effective cannabis use, and that includes understanding the type of product you're using, understanding how to titrate a dose, understanding the difference between an effective dose and a dose that's not high enough or too much. There's a number of considerations when using cannabis medically that I think education is required to make sure that both the patients, the folks who are dispensary personnel, as well as the qualifying practitioners themselves understand. And with an annual update on latest research, I think everybody could be kept apprised of developments that are occurring in the medical cannabis area. Nikos or Wendy, if you have anything to add to that, please do.
If I could just respond very briefly to the senator's question regarding method of delivery. That fundamentally is an individual matter, and an individual has to determine what works best for them at a given point in time, and that actually can change over time. So it's something that is worthy of consideration. And as a policy matter, I think it's incumbent on us as a state and, to facilitate the availability of a broad range of products, whether you're talking about, a flower that has been tested, whether you're talking about tinctures that have been tested, as well as edible products.
Wendy, Terry thought you might want to add anything. Do you want to add anything to that?
Yes, very much. Terry, thank you for that. I agree with everything that you said. I don't actually have a lot of clinical practice, but I have been studying this legal and medical aspects of cannabis for about 7 years. And I've helped educate about 400 medical professionals in Hawaii and about 1,000 other people who attended my presentations. But what I would like to say is that the need for education has been established. We've gone around and around with trying to figure out how we're going to educate as many people who need to know as we can, including law enforcement. And I'd just like to emphasize the need for us to establish some form of education among medical professionals, because patients are reluctant to divulge to their providers that they are using cannabis, and that can have devastating consequences with drug interactions with other drugs that they may be taking. And we also need to establish a reporting system for side effects and adverse events, and educate people about how to go about doing that. Caring for the medical cannabis patient is it's tricky, it's time consuming, and we need to be teaching medical professionals at least the basics about how their own body works and how the plant medicine works. Just basics stuff at minimum.
Thank you, Wendy.
So-
Senator, anything else before we move on to other task force members who do have some questions and comments? Senator, anything else?
No, nothing else. I mean, basically, my question wasn't whether or not whether or not it's an optional choice to smoke versus vape. My question was based upon the appendix on the contraindications of smoking and the negative effects, which is one of the unintended consequences as part of your report of cannabis smoking, whether or not any of those respiratory ill effects was in any way differentiated between smoking and vaping. And it doesn't sound like there has been any differentiation.
Well, the vaping is too new to have any long-term studies done on it, but there've been long-term studies done on smoking. So we are pretty sure about that. We know what most of the dangers are from that. Vaping, not so sure, except for, the tainted cartridges. But I don't know. Yeah, anyway, I do have concerns about the safety of the vaping.
Okay,
I'm sorry, if I
well-
could just interject really quickly. Some of those questions will be answered in the Public Health and Safety Working Group report.
Great, thank you.
That's
Okay.
going to be presented next week at next meeting.
Mr. Radulli, you've been very patient.
Also, I would like to clarify for Senator San Buenaventura, when in the context of unintended consequence, what we intended by that was any unintended consequence of a dual use program. It was not related to unintended consequence of medical cannabis use. We don't have that level of expertise on our group. So it was just more to do with there may be unintended consequences of a dual use program on medical use patients that we hadn't identified in our report to this point. Thank you.
Thank you for the clarification. Mr. Radulli.
Thank you. Just for the chairs of the group, I'm reading your patient protections, and you have a recommendation that the legislature changed the prohibition on law enforcement agencies denying or revoking the right to own firearms. Am I reading that correctly? And we're dealing much with these federal and state regulated programs. Cannabis is federal and state regulated, firearms, insurance, banking, all of these kinds of things. And certainly the things that Dr. Otto has been bringing up at our meetings. My question to this group is, even if we were to, for example, remove the firearms prohibition at the state level, it's really net gain zero if the federal government doesn't change their prohibition. I'll give you the example. As a state law enforcement officer, I'm required to carry a firearm. And so I cannot participate in the medical cannabis program because of the federal prohibition on cannabis. So essentially, I cannot keep my job if I get a card. So if the federal government doesn't change this, if for example, we were to change it at the state level, we'd face constitutional issues amongst those, including the supremacy clause and those sorts of things. Isn't it true in all of these issues, Terry, Nikos, the federal government has to really change their laws on this, or net gain is zero?
I think you bring up a really important point, and we felt our role was to advocate on behalf of existing medical cannabis patients. And we did find out that there is resistance by some who could benefit from cannabis therapy because they're afraid of losing registration on a firearm. They fear not being able to register a firearm. And you're absolutely correct. A lot of these issues go directly to the federal conflict that Dr. Otto speaks of quite often. But in speaking with the patients themselves, it's unfortunate because you do find that some of them will say, well, I just found out I have cancer, I'm suffering, but I'm afraid I'm going to lose my registration for my firearm, so I'm just going to go out and buy it on the street. I don't think that's the way to solve that problem. It's certainly not the ideal way to solve that problem, but there are individuals that are solving the problem in that way because they're afraid of being registered in the state's program due to the firearm prohibition. I'm not an attorney. I have no legal training whatsoever, so you may be right. It may be net zero and it may be completely dependent on the federal government, but we felt it was our duty to represent the concerns and interests of existing medical cannabis patients.
Your points are well taken, Mr. Radula. And if I could add to Co-Chair Gorman's statements, is that ideally there would be a change in federal law, and I've seen the forms, both the federal form and the form that's used at the county level. And what we have here is a regulation that treats people who use cannabis more disfavorably than people who may, for example, habitually use alcohol, which is a much more dangerous and much deadlier drug. So to the extent that state and local law enforcement can do, what the Honolulu Police Department did a number of years ago and kind of grandfather people in, but they're not, allowing, newer medical cannabis patients to get medical cards. I think we just believe as a committee that somebody who uses cannabis under under our medical cannabis laws not be precluded from owning a firearm, although I am not a proponent of firearms in any way, just to be clear. I think Mr. Gantz who's on the committee, might have something to add to that.
Sure, Mr. Gantz, and then we'll hear from Madam Chair of the county.
Sure. I wanted to just point out that while the federal conflict is an issue, it has always been an issue since the inception of legal cannabis programs in the nation. And it has been the courage and the braveness of states to step up and do what's right and allow equal access that has resulted in patients having additional access. So In places like New Jersey and New York, they have stated, even in regards to their police departments, that if police officers decide to use cannabis in their off time, that they're legally allowed to do so and they will not get prosecuted by their police departments. And yes, it's in conflict with the federal government, but this hasn't resulted in the federal government shutting down programs, slapping people on the wrists and telling us to reverse state initiatives. And when in terms of the firearm thing here, back in 2017, there were some letters that were issued out to patients that said you need to turn in your firearms to the Honolulu Police Department because they went to the database and picked up some individuals. And we were the only state that did that. And it really sent a shockwave through the cannabis community around the nation. And in my opinion, I don't think it's necessary. Again, while there's a federal conflict, there's a lot of federal conflicts in the cannabis space that have yet to come to some kind of negative repercussion. And it's been the recommendation of many places that we don't have that kind of conflict to keep people away from medical access. So I think it's an opportunity for us in the state of Hawaii to do what's right and to provide equal access. If you decide to own a firearm and you meet all the other requirements and you're allowed to, that if you have medical cannabis by your provider, then that should be good to go.
Mr. Redulia, any follow-up?
None at all. Thank you very much.
All right, thank you. Chair Nakata.
Thank you. Randy, did you have comments to make? Because you were actually lined up before me.
I just, secondary to all the firearm conversation, I did have a comment just on the report itself. And then given some of the testimony we had, it was about having language involved to prorate some medication for those who are underserved or lower socioeconomic status. And I know currently our language in the law does state that medical dispensaries cannot give away free medication, things of that nature. I do know that other states do allow that. They have some programs. I know in California and Colorado where they have veterans organizations that provide free medication from certain dispensaries to those who either cannot afford it or don't have that ability to show up and provide the monetary exchange. So I do think it's important that we consider that in our state, that if we do have a program in the future or even something that we address in our medical program, is to allow some type of language that allows dispensaries to participate in a compassionate program where they offer medication either free of charge or at maybe just an administrative cost.
Thanks, Mr. Gons. We're going to hear from Madam Chair and then Mr. Otani. Chair Nakata.
Thank you. So I just had three questions. First was regarding the testing requirements that I think Director Choi had brought up. I totally agree with the comment that Terry Gorman had made regarding the testing for by private citizens for personal grows. That is a personal choice, and it's not something that I would advocate in imposing on them. I did want to advocate for consideration that the working group's recommendation that the testing of commercial legal adult use products align with that for medical use. The medical use testing requirements are actually, they are extensive, but they're not onerous, and they are all evidence-based on the risks that are associated with market products. And the program recently revised some of our testing requirements to allow for safe production of edible manufactured products. And I know that the industry may have been taken aback by some of the expansion of the testing requirements, but our program stance is a brownie that you buy in a medical cannabis dispensary should be just as safe as a brownie that you go to Safeway's bakery and buy. And I think that's kind of the stance that we would argue for with regards to products that are serving medical patients versus the larger community. I don't think, I do think that the medical use population needs to be protected. I don't think that our our public is any less deserving of basic protections is I guess the way that I would put it. The other thing that I have learned from discussion with other states, and I'm sorry for, going on and on about talking to them, but to be perfectly honest, they serve as one of the main sources of the information for Hawaii. Is one of the strongest recommendations is as much as possible, adult use legalization regulation should be aligned with medical use programs because it reduces any kind of conflict or confusion by the industry, by consumers, and by law enforcement. And I would just make one quick comment. Take a look at the problem with hemp derived products and the difference between medical or illegal adult use cannabis products. And I would say that's enough said. That's the problem that happens when you don't align regulations. My second comment was regarding Senator San Buenaventura's comments about concerns related to suicide and depressive disorders. There is moderate evidence that has been shown to link bipolar disorder, depressive disorders, social anxiety disorder, as well as suicide and completion of suicide with use of cannabis. And in particular, it's with regards to heavy use of cannabis. So use of products that are high in THC content or frequent daily use of cannabis. So I do agree that this is something that is a responsibility of the patient's medical provider. It is something that it should be kept and honored as a part of that that relationship. I do want to clarify for the task force and anybody else who is listening that certifying providers are certifying that a patient has a qualifying medical condition. And very often, the certifying provider is not the medical provider who is treating the patient for that qualifying condition. So there is a very strong likelihood that the actual treating physician may have limited awareness or no awareness that the patient that they are treating is using cannabis to address their symptoms or their illness. This is one of the things that has been discussed among other states, and I had also raised with here is a consideration of linking the prescription drug monitoring system to the patient registry, as has been done in other states. And basically what it does is when a patient goes to fill a prescription, it triggers that the pharmacy when they are filling that prescription to provide to that patient some additional informational about the possible drug-drug interactions that prescription drug may have with cannabis. It also, in some states, and it depends on how you set up the system, it will send a notification to the physician when they go to renew or prescribe a medication that might have a potential interaction to a patient who is registered with the patient registry system, to let that physician know that their patient is a registered medical use patient and may be using cannabis to treat their symptoms, to encourage that provider to have that discussion with their patient. So that's just a comment that I have with that. The last one is just a quick comment on method of delivery, the vaping versus smoking. Cannabis smoke does have the same types of contaminants, particulate matter that tobacco smoke does have have. And so there is a lot of concern that it may pose the same types of risks as with regards to secondhand smoke exposure that tobacco smoke does. So that is something that does need to be considered. However, there is, as far as I'm aware, not very strong similar association between using cannabis in a smokable form and development of cancer as a result. And that's something that does need to be researched further. It's my understanding that there have been extensive studies looking at individuals who only smoke cannabis in a smokable form, use cannabis in conjunction with tobacco in smokable forms, as well as individuals who only use tobacco in smokable forms. And in some of those preliminary studies, it has been shown that individuals who only use cannabis in a smokable form actually have cancer rates that are comparable to individuals who do not use tobacco. So, but that's it's not very extensive, and the evidence in those studies, I would say, is still not very strong, or not even moderate. It is an area that still needs to be studied. But I just wanted to provide that comment. Vaping, by contrast, does not have some of the risks that are associated with smokable form of cannabis. However, because it is a manufactured product, it does bring in a lot of potential problems with regards to the manufacturing process, residual solvents, contamination, heavy metals, excipients, additives, and all of that kind of stuff that, as Wendy had mentioned, they've been in use not long enough for us to have a lot of information about what the long-term effects of lung exposure to those chemicals might be. I think we just saw the really acute example with the EVALI outbreak that began in 2019. And that's still being studied as well. Thank you.
Madam Chair, that was a lot. So before we hear from Mr. Otani and Ms. Chin, I want to give any task force member an opportunity to comment on what Madam Chair just shared. Does anyone wish to comment before we hear from Mr. Otani and Ms. Chin?
Just briefly, I'd like to share that Michelle is spot on with what she presented. The other issue is that folks who are unaware of pharmacy interaction with cannabinoids may not know that cannabidiol, commonly known as CBD, is much more promiscuous than THC, and meaning that it interacts with many more compounds. And it's one of the dangers of our current hemp program, because people think that CBD is along the lines of vitamin C and use it freely and frequently, but the chances of CBD interacting with a pharmaceutical substance is much higher than the chances of THC interacting with a pharmaceutical substance. That's all I wanted to add. Thank you.
Thanks, Mr. Chair. I would like to thank Ms. Nakata for her feedback, and I would like to underscore Ms. Gorman's point that she made a number of minutes ago about the need for more robust research around cannabis in all of its forms, research that has been heretofore limited due to cannabis being a Schedule I substance under the Controlled Substances Act. I would also note that, the injury that came from the EVALI episode were from black market or illicit cannabis products that contain largely vitamin E acetate, I believe. So mahalo.
Thank you. Mr. Otani, you've been very patient. Ready to hear from you at this point.
Okay. Chair Nakata actually asked my question on the first one there. But I just wanted to clarify on one point on there. So is that testing, because My concern is that to ensure safety and quality of all commercial cannabis for the statewide for medical use. So is that testing third party? And who certifies those third party? And the next question to that would be, is there ongoing testing, or is it just upfront for the thing, or is it sporadic testing to make sure that the standards are being met?
Thank you, Mr. Tani. Ms. Gorman or Mr. Leverez, do either of you wish to answer either one or both of those?
Yes, the testing is done by third-party labs that are certified under the Department of Health. And I think Chair Nakata could speak to the rigorous inspections and standards established for the labs, which I think are essential. There is evidence of a pay-for-play type of scheme that has popped up in other jurisdictions where there's some untoward things happening with the labs, which is why I think it is essential that the labs are inspected and certified by the Department of Health, and that they are, independent third-party laboratories, that continues.
And what about the second question? Is testing ongoing or sporadic?
No, in the existing medical cannabis program, no product can be sold in a dispensary that has not been tested. At least the batch of that product has not been tested and passed a fairly extensive battery of tests. So not every single individual product is tested, but the batch of that product is tested quite extensively. And if it fails, it fails. It can't be sold.
Thank you. Mr. Otani, does that answer your questions?
Yes, thank you.
Great, thank you. Ms. Ching, you've been very patient. Thank you.
No, thank you. I just have a question. Because I've heard a lot about not discriminating against people that have job discriminations, whether they hold a gun or. And so my question is, personally, if someone is under the influence, whether they were drunk or whether they had have medical marijuana, I would want to know if they are driving a bus or if they use a gun on their job, that they're fully aware and capable. And so I would want to hear more discussion on why shouldn't there be limitations regarding employment and use of medical marijuana or commercial marijuana, for that matter of fact.
Ms. Gorman or Mr. Leverez, you wish to respond to that question?
I would like to respond to Ms. Ching. I think we all agree with you that we don't want anybody who's in a situation where they are responsible for somebody else's safety to be impaired on the job, regardless of what their impairment is. And that extends to alcohol, prescription medication, as well as medical cannabis. The misunderstanding, I think, is that the existence of THC metabolites in a drug test does not indicate impairment at the time of work. And that's the greatest concern. There are a number of people who use cannabis for symptom relief. For example, they may have a terrible debilitating pain, or they may have cancer or some other condition that cannabis helps to relieve it. And therefore they will have THC metabolite if they are required to take a drug test. Just the presence of THC metabolite in somebody's urine does not mean they're impaired on the job or they're unsafe in any way. Just because THC binds with fatty tissue as opposed to removing from the body with waters like cocaine or alcohol does, the presence of that THC metabolite only means that you use cannabis. It could have been a small amount, it could have been over the weekend, and you could be completely sober at work. And we think it's discriminatory. Now, if somebody is impaired at work, regardless of what they're impaired by, there should be consequences for that, whether that be alcohol, Ambien, cannabis, whatever it is. People should not be putting other people's safety at risk because they're impaired on the job. And I think that goes across all substances. We just feel that cannabis is unfairly stigmatized, and that's probably due to ignorance on what drug testing is really testing. And California just passed a law saying that just having metabolites in a drug test is not sufficient to lose your job over that.
Thank you. So basically, the issue is whether the testing is appropriate to determine impairment
Correct. That's
while
correct.
you're on the job or
While
not.
you're on the job, right?
Would that be an accurate statement?
Yes, regardless of why you're impaired
Right.
on the job, you should not be impaired on the job. But if you're not impaired on the job and you just get a random drug test and they go, oh, look at this, there's THC in the results or THC metabolites in the results, we're going to have to let you go. We think that's discriminatory and very unfair.
Thank you.
Mr. Leperez, Ms. Gorman's answer was very complete. Anything you wish to add?
No.
Okay, thank you. I've got a question or comment from Mr. Hollyer. Garrett?
I just wanted to add to Terry's excellent answer in that the social equity group report also has a section on this, including being in complete agreement with Terry and also including some additional and specific ways that you could test for impairment on the job or otherwise limit, especially to those jobs where safety is a very particular interest, still establish protections in those areas while not, like Terry said, requiring any metabolite to be in a zero tolerance policy to eliminate you from that job.
Great, thank you. Pretty exhaustive discussion. I don't have any other names listed of people that wish to ask any questions or make any comments. So Madam Chair, I think we're prepared to turn it back over to you.
Thank you. And thank you, everybody. I think this was a great discussion. I really appreciate everybody's participation and all the hard work that went into the working groups. Next meeting is next week, Monday, October 3rd. And on the agenda, we have the presentation of the Public Health and Safety Working Group report. And we will have our discussion on the taxation and market structure working group reports that was deferred from the September 19th meeting last week. And I think that's it. So meeting adjourned.
Mahalo,
Thank you.
everybody.
Thank you.
Thank you, everyone. Aloha.
Aloha.